Hello, I'm Robert Bateman, and this is the Privacy Corner, where I talk you through my top 3 picks for privacy developments each week. And thank you, as always, to Privado AI for sponsoring the show. So this week, noyb is taking aim at ChatGPT's hallucinations, saying that they violate the accuracy principle and that OpenAI doesn't fulfill data subject rights. Do they understand how generative AI works? A lot of people are saying they don't. I think they probably do. 200 million in penalties for mobile carriers in the US, selling data to data aggregators, very similar to FTC enforcement action we've seen recently, but this comes from the FCC, the Federal Communications Commission. So let's take a look at those fines. The FTC has finalized its health breach notification rule, and it's very clearly not about just data breaches anymore. I mean, arguably it never was. Certainly it hasn't been used that way recently. Now it explicitly isn't. So noyb, Max Schrem's campaign group, has lodged a complaint with the Austrian DPA. We'll come back to why that's interesting soon, about OpenAI and ChatGPT. So an anonymous complainant, who I suspect was Max Schrems, asked ChatGPT to provide his date of birth and got the wrong answer. He submitted access and erasure requests to OpenAI. He asked them all sorts of things about, well, the sources of his personal data, etc. We'll come back to that very shortly. And also an erasure request. He was not satisfied with how these were handled, and so he lodged a complaint. With regard to the access request, the complainant wished to receive information about where the data came from, what the legal basis for processing it was, how long ChatGPT plans to store personal data about him, and who else it provided this false information to. So obviously what the complainant is getting at here is the training set by which ChatGPT generated this false date of birth. Now, the complaint itself makes allegations about 3 articles of the GDPR. 12.3, which is about dealing with data subject rights requests, the timing and modality stuff. 15, which is the right to access, which he says that OpenAI has not fulfilled properly. And Article 5.1d, which is the principle of accuracy. Note that there is no allegation about the right to erasure. Now, there was an erasure request submitted. I'm not quite sure what they wanted to achieve with that, but OpenAI said effectively we can't prevent ChatGPT from producing personal data that is inaccurate, which is true. This is how these models work. They work on a statistical basis. They string together tokens that are likely to appear next to each other, but they don't know what's right and wrong or inaccurate or accurate. So OpenAI is obviously a US-based non-profit. They do have a commercial arm, and their non-profit status is complicated, but they are established in Ireland since last year. However, noyb says that the Austrian DPA should take this on and that the one-stop shop doesn't apply. Now, the EDPB recently put out some guidance saying that it doesn't really matter where you say you're established or where you have an office. If you're making decisions about the purposes and means of processing outside the EU, then you're not entitled to the one-stop shop. This is quite controversial. If this works for noyb, then it will probably speed up a lot of these types of complaints where they go to Ireland, they sit around for a few years, and then eventually they go to the CJEU. The one about Meta's legal basis took 5 years to resolve, so that will be a significant victory. As for the substance of the complaint, what do we do about large language models and their apparent contradiction of the principle of accuracy and the inability of their providers to give detailed personal information or information about personal data under the right of access, right to rectification issues, there's right to erasure issues. I don't know how this will work out, but it could be a rather big deal if it gets to the court. Poland might be first to refer to the CJEU. Łukasz Olejnik has got a case there that was lodged much earlier than this one, so we'll see who gets to the court first. Next up, We are looking at 4 fines totaling $200 million against a bunch of companies that unlawfully, allegedly, sold personal data to data aggregators. This sounds a lot like it should be coming from the FTC, who had 2 cases that sound a lot like that this year alone, but it's actually the FCC, the Federal Communications Commission, that regulates wireless carriers and other communications networks. So these are against Sprint and T-Mobile, who have merged since the investigation started, AT&T and Verizon. I read their data breach report every year, but never sure how to pronounce it. And well, what happened? Well, let's look at an example. AT&T, one of these companies, they all seem to have done pretty much the same stuff. We're running what they called a location-based services program until March 2019. So they were selling information about their customers' location to location information aggregators, 2 companies, who then resold it to third parties, 86 of them in total. This was happening without consent, and there was a contract in place. There were contracts all the way down the chain, but the FCC is not happy about how this played out. So AT&T did an audit of these 2 location data aggregators at one point, and they found security issues. They say that those were resolved. In other cases, these wireless carriers were relying on third parties to obtain consent. That shouldn't have been how it worked, according to the FCC. They were offloading their responsibilities. Now, the relevant law here is Section 222 of the Communications Act. So let's dive into that and just have a little look at what it requires. Effectively, wireless carriers can't share individually identifiable customer proprietary network information, CPNI, so that's data about location, for example, unless necessary for providing their services, effectively, unless they have the approval of the customer. Now, the FCC interprets this as opt-in consent. They can share aggregate data for other reasons, but this data was deemed not to be aggregate. The definition, as I say, of CPNI includes location, and aggregate data is where individual customer identities and characteristics have been removed. So again, we have a case of companies sharing data that they say is in aggregate, or they say they got consent, and the US regulators applying narrow and high standard interpretations to those concepts. The FTC is all over this. They had cases against data aggregators themselves this year, InMarket and XMode Social. There's a huge shift in how this stuff works in the US, and now it's playing out with the FCC as well. So since this case began, the FCC has set up a privacy and data protection task force, and they say that these things are a top priority for them and critical to all Americans. So that really underscores the point that this is a very actively changing landscape in the US, and all companies need to be thinking very carefully about how they treat personal data. So next up, the FTC, the Federal Trade Commission, has finalised some changes to the health breach notification rule. Now, they've been applying this version of the rule for a couple of years now, if you ask me, but now this interpretation is official and on the face of the rule itself. So the health breach notification rule derives from a statute that gave the FTC powers to write it. And in 2021, they sent a letter made a statement about health apps and other connected devices and how they were covered by what looks a lot like a data breach notification rule, but is in fact, according to the FTC, a prohibition on sharing certain types of health data without consent. So they have enforced the rule as such against 2 companies last year, GoodRx and Premom, who were using their app to share data with Facebook, Google, etc., analytics, advertising stuff without consent. Under the new version of this rule, we have revised definitions, think broader, so types of data that it applies to, types of vendors that it applies to. We have the interpretation of what a breach of security means, incorporating this view of the FTC that it includes advertising data being sent without consent, and also new breach notification requirements, earlier notification to the FTC, and cosmetic changes. Quite a lot of stuff happening there. So the rule takes effect, the new rule, 60 days after its publication in the Federal Register. I think that's around mid-June. There's a precise date that I calculated and take no liability for in the newsletter. And it was not uncontroversial. We had 2 of 5 commissioners dissenting on this, saying that the FTC is going outside of its powers under the statute that gave it the powers in the first place. They don't think it should be interpreted quite so broadly. But until it gets overturned by a court, this is effectively the law now. And again, the kind of flagrant sharing of data that we've seen in the US over the past decade or so is coming to an end, I think. We need to be a lot more careful now about how we use health and personal information in general. So that's all from me this week. Thanks so much for your time and attention. Thanks again to Privado AI, and I'll see you next week.